I could not inform the other side. I could not get them.
Okay.
So I can renew my prayer when the matter reaches.
You need not be here.
Fine.
We'll pass the
I'll be
appropriate.
so obliged.
We'll pass the appropriate.
Obliged. Mention a criminal revision petition we filed on last Monday.
It cannot be here. It has to be before the senior bench. Yes, why the hesitancy in coming forward? Yes.
Item number 4, Your
Why?
he was the earlier engaged counsel there, Your Lordship. Right now, we have come to know that he has left the profession and the
Miss
S. Nazneen, Your Lordship.
S.
Nazneen, Your Lordship.
Nazneen, learned counsel for the petitioner, submits that the brief of the matter is misplaced in the chamber and submits that an accommodation be made to facilitate the learned counsel for the petitioner to facilitate reconstruction of the brief. Prayer accepted. Registry to list this matter again on 14/10/2025. No further adjournment would be granted in the matter. 2012 matter.
My little lordship wanted to.
What happened? Where are they?
I have come across the general rules matter. I have mailed it to the court master. There are a general rules matter under section 40.
40.
40.
141.
141 page matter. Chapter 5 exclusively deals with that matter. That will be.
Chapter 5 to kiman pages? Bottom page kita ulai dio. Let us wait for the
My lord.
whether they have got that information that you have got. Let us see. Time being.
Item 3.
None appears for the petitioner on call. Charge under 147/326, but subsequently it was 324. 1 year. Where? We will wait for some time. So the so knowledge was imputed. 379 has been established.
After the purchases are not matter that
Sale deed is also there.
it's a PW5 man.
Guilty. That's why he was the second possessor, basically. So PW5 is the only saving grace. Hmm?
What is implicated, my lord? That
No, that is for the 3 and 4. That is for the recovery.
recovery.
But 5 says that he was witness when certain papers were signed and the accused had bought the vehicle, bought the cycle. So that was not considered. Unreliable witness. But he is a prosecution witness. He was not declared hostile. Okay, wait for some time. Yes.
What I mean, my lord, he's coming. K. Raj Chaudhary is, my lord.
Aram sir. No rush.
Lot of breath.
You take your breath. Have one where we'll after this matter, next matter we'll take it. Get your breath back. On the verge of puja vacation, do you think this court will proceed suo moto in these matters? Never.
My lord. At least from this court,
Never.
we are 100% confident about
Never.
that.
Yes. 7. Yes, Mr. Soikia wanted to go through the. What happened?
Or is it
Huh?
senior is in another
Okay, today everybody is in another court. Hey, Roy Chaudhary sir, matter to do. 6. Yes, Mr. Chaudhary, what is there?
My lord, conviction under 406.
Hmm.
The only allegation, my lord, I am the principal of a school, headmaster of a school. My lord, I was interested with the question papers.
That
Hey.
got leaked.
On that day, there was no examination. Then notice was sent and they seized those question papers from me. Allegation against complaint, allegation against misappropriation, allegation against doing something wrong with the question paper or shortage of question paper, nothing was there. Because under 406, my lord, entrustment legally I made it
Entrustment is proved.
proved.
Hmm.
But I have done nothing with that. And there are 2 sets of evidence witnesses, prosecution witnesses. 3 has said in my favor, 3 against me. And against me, who has said, the person who have said in my favor has been told that they are interested witness. On that basis, conviction has been held for
One of them is that Chokida.
Chowki, the PW3. PW3, he is an interested witness. And my lord, another aspect of the matter, if your lordship can look into, in 313 statement, the question that, because the question papers
What
were,
is your plea with regard to non-holding of the examination?
my lord, my statement in 313 that the examination was held.
And that was also corroborated by one of the
My lord,
prosecution
my lord,
witnesses.
my lord.
Okay. But Mr. Chaudhary has put it very simply. You go through the evidence. But Mr. P.K. Roy Chaudhary, learned counsel for the petitioner, also heard Mr. R.J. Borua, learned counsel for the respondent. Mr. R.J. Borua, learned counsel for the additional public prosecutor, submits that he be granted an opportunity to peruse the trial court records. For prayer accepted, a registry to list this matter again on 17/10/2025 for further hearing.
Obliged, man.
I may have to go against you, so I don't want to do it before the vacations. May.
My lord, I understand that may. My lord, only thing, my lord, I got a judgment from the Supreme Court. My lord, the main sphere is the essential ingredients of 406. My lord, one thing I take it likely that way, my lord.
What is that
Examination-
decision?
My lord, the decision, my lord, 406 I have got. 2021 18 SCC page 70, my lord.
2021?
18 SCC page 70. Page 70. Main sphere is a fundamental ingredients of. But another question, if I can hypothetically put it that way, board examination is held on a particular day for all the schools.
Hmm.
On that day, the examination was not held, assuming there was no examination held, my lord. The question papers were with me, and on a requisition, they have seized those question papers from me. So, my lord, after the examination is over, those question paper, I will not do anything wrong with that, and nothing remains with those question paper.
We'll see.
My lord, there may be a misconduct in the service career regarding not holding of my examination. But where is this criminal intent? Because those question papers were with me, and they have seized from me.
There is no allegation of any misdoing with the question papers.
Question papers. No allegation. Nothing was.
We'll
there.
see.
All right.
Borua, you go through.
My lord.
Yes, Mr. Rahman, what have you found?
Lord,
LIC policies.
LIC policies. I have very poor preparation, my lord. I do not have the witnesses, my lord, Ws.
I will-
Even though I have gone through the judgment, your lordship.
Hmm.
For my limited understanding is that, my lord, section 420 and 471.
Hmm.
Here, the case is not for conviction, your lordship, not be convicted. Well, the learned trial court.
Yes,
Sorry, my lord. My lord, I have pointed some.
have you given a copy to ma'am?
Look, this is. For the 21%. This 3 and 4 may kindly. Consider, your lordship, will decide.
Is the loanee who had given the documents. So it cannot be said that he does not have any role in there.
A sort of statement was given by the bank manager. briefed, but the bank manager BK Devnath and Romaniok have been paid based on their own statement that stated that the documents submitted by the applicant based on which loan was sanctioned. Your Lord.
Just a moment, give me a moment. Arubala is involved in which case? And her husband is? Devnath, that bank manager, is the respondent of PW?
Accused, my lord.
Hmm?
Bank manager was.
Oh,
not
sorry,
accused,
accused,
my lord.
accused.
Co-accused.
Yes. So your case is basically that these were not done by the appellant's hearing, it was done by the bank.
Learned trial court before
Oh.
convicting the accused.
Hmm.
had not decided as to whether the appellant had submitted the
Hmm.
LIC policies or not.
Hmm.
That is totally silent, my lord.
Hmm.
For statement of the accused persons
Hmm.
as given before the police officer court
Hmm.
that stated that they had not given any documents except for photographs,
Photographs.
my lord. And
That is the common stand taken.
my lord. That has not been decided. In respect of 420, my lord, they had taken the loan and started the repayment, and accordingly they have
Repeat.
repaid. So 420 not at right. My lord, beyond all reasonable doubt.
Okay. Yes, madam.
To Bharat Chandra.
Hmm.
In particular.
Hmm.
Stated all the accused that is loaning.
Hmm.
Get the loan.
Hmm.
Of the judgment.
Down below. Down below. Last line.
Bharat Chandra, who actively assisted the accused Thakur fraudulently sanctioned the
C. Thakur is the branch manager.
branch manager. Manager and probably
Then you come to
he-
BK
he ex-
Debnath.
he expired.
He expired.
He expired.
Mala Sharma is his wife.
And a PW 11
Okay, ma'am, we'll go through. What is your sum and substance?
actively played role in getting the loan of these accused person who are involved. And in few of the document, they have enhanced, like if it were the LIC paper 1000, prefix 5, prefix 4.
But, and the reports that were received, that were also, assignment reports were also forged.
Pre-planned, and it has been done in the knowledge of all the accused person. That is why they have come, because he has only facility for getting the loan. It is okay. Some of them has prepaid. There was a meeting, and meeting was called for by the bank authority. And they told them that there is a irregularity. So out of fear, some of the loanee has paid the amount. Does the payment
That will not absolve them.
absolve their liability? That is the case, your lordship. Bharat Chandra, PW 11, 13, 14, and 16.
Ma'am, can you just give me a small note on that? By tomorrow?
There are many cases in lordship's court.
Not declare counsel for the parties at length. Hearing remains including. We are not hearing this matter anymore. You just give me that note. Registry to list this matter again on 1710. You are here on 17th, or your junior can handle it. 1710-2025. Also, the Learned Council for the Learned Standing Council, CBI submits that a written argument would be filed in the matter on the next date of listing. Also, prayer is Learned Council for Learned Standing Council, CBI prays that she be permitted to file a written argument in the matter on the next date of listing. Prayer accepted. The Learned Amicus Curie has already filed a written note also, which is taken on record. Raised it to list this matter again on 1710. Huh?
Separately for all appeals, I will give
However it's convenient to you.
there of with regard to Ashok Saiki.
Ashok Saike, huh?
Yes, Lordship has the last occasion asked me to write some judgment whether the case of the private person, if
What will happen?
yes, I have the
Mr.
judgment.
Kamar was also to address this.
I have a latest judgment.
Where is Mr. Kamar?
Or is in another court.
We'll take it up after. Let Mr. Kamar be also here.
Set of cases 11 to 17.
We'll have it
I-
after vacations, don't worry.
After vacations.
Not quite very well. 11 to 17.
11 to 17.
We had heard this matter at length. Tomorrow, madam, it will not be possible also to keep the matter, deliver the order, because I'll not be here from Saturday. So it will be difficult for me also after the vacations.
After the vacation,
No problem, no problem. Accommodated. Yes, amount cleared.
Yes, sir, we have taken instructions from the bank and there are no outstanding dues as on date, sir.
Okay. None appears for the petitioner on call. Miss N. A. Biani, right?
On behalf of R.K. Bhatra.
Learned Counsel appearing on behalf of Mr. R.K. Bhatra, Learned Counsel for the respondents. Heard, huh? None has appeared. Also, the present revision petition has been instituted by the by the petitioner herein, assailing the judgment dated 28/1/2013, passed in CR case number 6467/06 by the learned SDJM-2 Kamrup, convicting the appellant under Section 138 NI Act and sentencing him to simple imprisonment for 2 months and further compensation of ₹5,000. So the petitioner has also assailed the judgment dated 3/8/2013, passed by the Additional Session Judge number 2, Guwahati, in Criminal Appeal number 46/2013, partly allowing the appeal, modifying the conviction and limiting it to a sentence and sentencing the petitioner, upholding the conviction and modifying the sentencing to the effect that the petitioner was now required to pay a fine of ₹5,000. In addition to the amount of compensation awarded by the Learned Trial Court for the offence under Section 138 of the NI Act. Also, on the last date of listing, this court had required the Learned Counsel for the respondents to receive instructions as to whether the entire check amount along with interest has been paid by the petitioner herein to the respondent bank. Also, today, Ms. A. Biani, Learned Counsel appearing for the respondents, has submitted that the petitioner, in the meanwhile, had cleared the dues receivable by the bank, and accordingly, the the compensation as awarded by the learned trial court has already been paid by the petitioner herein. Also, in view of the above position, this court directs the petitioner herein to appear before the court of the learned subdivisional judicial magistrate bracketed S-2 Kamrup and to deposit the fine amount of rupees 5,000 as awarded by the learned appellate court by judgment dated 3/8/2013 in criminal appeal number 46/2013 within a period of 2 months from today. So the realization of the fine amount of rupees 5,000 words or lihidiba is full stop. In the event the fine amount of rupees 5,000 is not paid, not deposited by the petitioner herein before the learned trial court, comma, he shall suffer, it is directed that he shall suffer simple imprisonment for 1 month for the offense under section 138 of the NI Act. Also, the learned trial court to maintain, to monitor, to take steps for realization of the said fine amount from the petitioner herein. Full stop. With the above observations and directions, the present revision petition stands disposed of. Yes. That temporary defalcation of that money,
Yes, my lord. Perhaps no ambiguity of doubt, my lord, because
he had kept it.
yes, and he has also admitted that.
And last day we have given the copy. Have you given a copy?
No, yesterday late I received it.
Oh,
but
he said, Joakali. It here. Joakali 24, Aji 25. So it is seen that in pursuance to the directions passed by this order, by this court-wide order dated 19/9/2025, the learned counsel for the petitioner has received a Xerox copy of the present revision petition yesterday. So, in view of the above position, so a copy was also received by the learned additional public prosecutor. I have heard the learned additional, none appears for the petitioner on call. I have heard the learned counsel for the learned additional public prosecutor at length.
recovered the amount of out of 15-13 lakhs received.
Received. We'll have to, there's no jurisdictional error here,
No, my
no perversity. So hearing concluded, raised it to list. We'll give them one chance. If they come and say something, fine. Otherwise, we are dismissing this. 17 for delivery of orders. Yes, Mr. Ahmed.
Here, Lordship, that sending the FIR to the magistrate, there was delay of Lordship around 15 days, Lordship.
Yes, have you examined that?
Yes, I have examined, my lord.
Hmm.
There is a note, my lord.
Hmm.
It is admitted, my lord, that FIR was, my lord, was placed before the magistrate on 16/10/2020, my lord.
Hmm.
Also, my lord, the date of incident of my lord 29/9/2000 and the FIR was lodged on 1/10, my lord.
Hmm.
It was mentioned that, my lord, after the lodging of the FIR, my lord, the
Hmm.
victim person, my lord, she fell sick, my lord. She could not come to the police station for further investigation.
But
On that
FIR was registered on the same day.
day, but on
So
that
if it
day,
is registered, it should have been sent. Why was it not sent?
one aspect of the matter, my lord, 154 CRPC, my lord.
Hmm.
My lord, that FIR has to be, my lord, placed on the very same day, my lord, when
24 hours,
Or-
there are decisions of the Supreme Court. Then 24 hours. And that is a very vital right because that is only for the purpose that this is not subsequently changed or incorporations made. That no explanation.
my lord, due to since
That is for recording 161 and taking the matter forward. That's a different thing altogether. That they can. That will be a valid explanation for a delay in the conclusion of the investigation. But how do you justify this? Any decision? Any decision?
That Lordship may kindly see section 157 first, Lordship.
CRPC. 1?
157.
Yes.
157. Procedure for investigation. If from information received or otherwise, an officer in charge of a police station has reason to suspect the commission of an offense which he is empowered under section 156 to investigate, he shall forthwith send a report of the same to the magistrate empowered to take cognizance of such offense upon a police report and shall proceed in person or shall depute one of his subordinates or other part, let's say I'm not disputing, so that he shall forthwith send. The another aspect.
Now, Mr. Ahmed, one thing. This by itself will not take
Yes,
the
that is true.
offense
That is
away
true.
from you.
Yes.
Now, this can be one of the factors to come to a conclusion that, see, there was some deliberation between the parties, and this was done subsequently only to bring you within the
That is
purview.
why I was pointing to other facts before your lordship. The other facts your lordship will see in the FIR itself. It is mentioned that 29/9/2000 at 2 a.m. occurrence. And she was medically examined on 30th. That your lordship will find in the doctor's evidence, page 15. page
She
15.
was examined the
39
same next day.
Yes, next day,
Mm.
and FIR was lodged after thereafter, Lordship, on 1/10/2000, Lordship. Page 4, your Lordship will find her signature and date. When then she would see.
But she had come with a police requisition on that day.
Yes, police even
But the GD entry was not.
not there. And I am taking your Lordship to the evidence of PW5. Your Lordship will find that victim herself appeared before the police station. It is not a case that she did not went to the police station or she was severely ill or injured. That is not the case. Page 18, Lordship may now kindly see cross part. Third line, she came to the PS on 3/9/2000. But she did not lodge any case on the same day. So I am relying on a judgment, Lordship, where Lordship 12 hours delay was there in lodging the case, whereas the police station was 100 meters away, and Supreme Court take it that there is Lordship considerable delay in lodging the SIR. In my case also, she went to the police station. She did not lodge any case.
Have you gone to? There is no GD entry.
My lord.
No GD entry. It is
GD entry is there.
So, my lord, only on 110, my lord.
Because the case
Why-
diary is
yeah.
found to, the case diary that is there, it's only from 110 after the case was registered.
Yeah. 110, then after that directly, my lord, from my lord, or 110, lord, you will find directly 16.
But 39, there is a requisition. 39, there is a requisition here of the SI NH Borbia.
Regarding delay part, my lord, if the facts. Also, the several Supreme Court. Then maybe, my lord, it can. I think lodging of FIR. But this case, my lord, the FIR was lost, my lord. But it was not, it was forwarded to the magistrate on 6th. But my learned friend is submitting.
And that by itself will not.
Two parts here. Lodging of delay, there are 2 days delay, and sending it to the magistrate, there is 15 days delay.
But how was she forwarded to the requisition made for her medical examination without a GD entry? Has to be there.
There has to be a GD entry. So admitted that before registration of the case, no GD entry was made. She was sent for medical in connection with the present case, that is not there.
And the medical examination is in response to that requisition. Exhibit 1.
It's 34.
But these aspects were not brought out during the cross-examination.
There was to some extent cross-examined, but other was
Not in the manner you are now trying to project the matter.
that
So the unreliability of the evidences adduced.
Arguing for unreliability. I am only arguing, Lordship, whether
But that delay in the forwarding of the report by itself will not be
by
fatal.
itself it will not. But
Okay.
my humble submission for your Lordship is that there is lodging of there is 2 days lodging of delay in lodging the FIR is there, and on earlier
Explanation to that effect would have been better, but
it is not.
unfortunately, it is not there. But the evidences otherwise coming on record is
Your Lordship has on other day seen that from FIR, her deposition, and in 164.
164, there is a variation.
Variation. So those all.
So we have also seen that there is a time gap also. And the contradictions are very minor.
But the manner in which the offense occurred, that has to be seen, Lordship.
See, if a village, a lady, a rustic lady like her, repeats the verbatim the same statements, it may also create a doubt. But here it's natural, seems to be natural, omitting something.
I'm placing for your Lordship is that when she deposed before a court, when any person deposed before a court, your Lordship will, apart from conduction, your Lordship has to see that whether her version is reliable, believable or not. The incident in which she described
See,
the incident.
You had a case, you made out a case of ill will against you,
Lord.
grudge against you.
Lord.
But that was demolished by your own witness itself.
So I will say, Lordship, it was not proved. There are three parts: proved, not proved, and disproved. So I will say, Lordship, it was not proved. The disproved part will not come here. And the judgment which I have referred, the Lordship may kindly see.
That is a bit difficult here because that statement of the clearly reflects that you have made a misrepresentation in 313.
I have submitted to your Lordship that it will be treated as not proved.
Where is the decision?
Lordship, that Rajivan and another. Here, Lordship will see that there was delay of only 12 hours. Now, Lordship may kindly see paragraph 12. Twelve, 13, and 14. I think that sending of report.
Okay, we'll examine.
So it is admitted position that she appeared before the police on 30th itself.
But the FIR was not lodged.
Not
She was
lodged.
sent for medical examination. Yes,
And
Mr. Borwa, anything
regarding
more?
that, her initial statement also no GD entry is there.
My
In
lord,
connection
otherwise
with
he is implicated, my lord, that is corroborated by doctors. Right, my lord. My lord, caused by the. That was registered after the, my lord, was medically examined. My lord.
But Mr.
and just one thing, if I may point out, that that her earlier state, the cross
Variations.
earlier Lordship, she lost 2 cases where the accused persons got acquitted, Lordship. So her previous conduct, that will be a relevant fact, Lordship, in the present case under Section 8 of Evidence Act, Lordship.
Any decision?
Another decision, Lordship, I have given one on Naresh Elias Nehru on the other day, Lordship, paragraph 9.3, regarding that Sterling
Naresh Elias?
Nehru,
Ah,
versus State of Haryana. Here, Lordship, paragraph 9.3.
citation?
That is, Lordship, recent judgment, Lordship, 9th of, that's
Bring good.
Supreme Court, Lordship. INS is there, 2023, INSC 889.
That is the
Neutral
Supreme
citation.
Court
Yes. neutral.
decision by
Decision by Lordship, Honorable Mr. Justice S. Ravindra Bhatt and Honorable Justice Arvind Kumar. Your Lordship, 2012, 8 SCC was relied on.
2012, 8 SSC.
At page 21.
Hut-
Regarding that sterling quality of
Witness.
that
We'll examine.
no.
But Mr. A. Ahmed, learned counsel for the
Another prayer of alternative prayer, Lordship, that here he was convicted for the maximum term, that is 5 years. Minimum sentence is not there, Lordship.
how long was he behind the bars?
That stop placing that. During investigation, he was there, Lordship. That I will give.
Give it to him. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R.J. Burwa, learned additional public prosecutor. Hearing concluded. Registry to list this matter. 3 date of day. Basic matter. 22/10/2025 for delivery of orders.
Oblige, Lordship.
Just give that particular. But Mr. Burwa, we hold that these are technicalities which is not fatal to the prosecution evidence. But there were 3 cases in preceding this case against the petitioner appellant hearing. And in all those 3 cases, he was acquitted. Admittedly, there seems to be something. Will it not be a fit case for probation? If we hold against him, the conviction is also upheld. It's a fit case considering the delay, the earlier conduct, and the delay today from the date of the judgment, as well as the conduct between the parties from before.
This is concerned about the indicated.
Conviction will be upheld. The conviction if upheld,
457 and 324 it is proved, my lord.
if it is upheld. But given the history and the nature of the injury, the punishment is for the lurking house trespass, basically.
5 years has been.
5 years will be given. Okay, we'll consider.
Item 1 and 2, my friend has submitted that rule. Here, apart from my earlier 2 points of argument, and another, my lord, the petitioners were in custody for 21 days during investigation.
Yes, Mr. Gugoi.
Lordship, in this matter,
Mr.
want-
Das, who is appearing in the other matters, have brought on record your rules. Ki naam hai rules, sir? From page 2. Transit rules. Now you can only deny this. You can have a copy. There is a soft copy available with the court master. You can have it from. Okay. Mr. R. Gugoi, learned counsel for the petitioner. For Mr. R. Gugoi, learned standing counsel, Forest Department, who was requested to assist this court in the matter, submits that the instruction he has not received complete instructions from the departmental authorities, and accordingly prays that the matter be taken up immediately after the ensuing puja vacations. So prayer is not objected to by the learned counsel for the petitioner. Accordingly, registry to list this matter again on 27/10/2025. No further adjournment shall be granted in the matter. Item number 1 and 2, ekkalage koidiva. For further hearing.
I'm obliged.
May I please, your lordship? My lord, there is a concurrent findings, and he was convicted for 6 months on the
Hmm.
404
Hmm.
A
Hmm.
motor accident case.
Hmm.
The fact, my lord, here is that the allegation is that the two person were going on, he from the behind has hit him in a rash and negligent way. But that has not been proved by way of MBI or by the police, my lord. No scratch map.
What do you say about PW1?
My lord, PW1, he's saying in rash and negligent. That is the issue. But what is the rash and negligent? That has to prove from the MBI report.
How?
Because MBI report will come therein. If it is a rash and negligent, the man would have been thrown. But the motor.
No, the case here is
Yes,
the man was caught in between the vehicle.
that is what I am saying, my lord.
Show me that should be the inference.
I'm coming, my lord. It's a question of our High Court also. I'll show it that, my lord. First thing, my lord, rash and negligent. What was the speed, my lord? First thing that, what was the speed of the rash and negligent in a PW road? Whether that has been assessed, my lord. Who will assess it, my lord? MVI.
How will he assess?
He'll go to the spot, my lord. The duty of the MVI is to, when there is an accident, he has to go there. And he has to verify what was the damage to the vehicle. Whether his mortgage, what is the impact of his hardness, my lord, that he has hit him in a high speed. Suppose your lordship has also driven the scooter, we are also driving the scooter. If a person is hit from the behind in a high speed, the man would be thrown away, at least 2 feet. But here, the motorcycle fell over the person because the submission was given that the lady was in the left side. She said, I was in the right side. So tried to cross it. Then there was an accident. That was the issue. Now,
So show me the decisions that should be the approach.
yeah, Lord,
It's only the lady and the PW1 which have to be considered.
Lord, and there's no injury on the dead person, my lord. Your lordship will see the postmortem report. Had it been a hard hit from the behind, there should be some bruise in the body. Nothing is there. He died of shock, my lord. Lord, here is the judgment of our High Court also. I just rely on this to judgment, my lord. Because that is very important, my lord. Our court has also said in paragraph 9, my lord, relied on Supreme Court judgment, your lordship. Submit the report. That is a very vital document, my lord. MBI report. Even the police did not go on the spot to make the point of perception, my lord. Which prosecution has failed to prove that in that way.
2 minutes.
Yes.
2 minutes. So para 19 of this judgment, there was no evidence therein that the vehicle was being driven in a rash and negligent manner.
Yes. Was to prove the rash and negligent, my lord, 304A, there must be a report from the MBI. What was the impact on the motorcycle? What was the injury on the person? Because the speed has to be seen, my lord.
And the second case, which is the paragraph you want to rely?
My lord, that is 8, paragraph 8, my lord, that is the submission. Last 14 will go. 14. Last 14.
Anything more?
No, my lord, I'll say only.
Yes, Mr. Goswami.
Here, my lord, regarding those judgments, my lord, I've not gone through the entire, my lord, but what I could find out that it reflects that there is no evidence of rash and negligence. Kindly come to PW1, my lord.
PW1
It
is
was
that.
very specific, my lord. My lord, the motorcycle was driven in a very high speed, and he narrowly missed him. And yes, both the wife also injured, and the other one who succumbed to the injuries, my lord.
Mm.
If you go by the speed, my lord, if the speed was in a lesser speed, my lord, that the accident would not have been out of proportion, my lord.
It's
That-
not a car or a four-wheeler, it's
Yes,
just
but
a
if
two-wheeler.
people see the circumstances at the scene, my lord, there was, my lord, the midst of the wheel, my lord.
So that is why the learned trial court did not hold him guilty for 30.
Yes, so
That last part of the judgment, you will not see, he himself said that. I have heard that. my
there
lord.
is no denial to the injury and
There is a
accident, my
paragraph,
lord.
paragraph
Yes.
30.
Yes.
There is no
30.
denial to the
He is
accident, my
himself
lord.
saying that. My lord, my only point is this, my lord, nothing else, my lord. If the motorcycle has been a rash and negligent driving, my lord, the man would have been injured.
Mr.
See the-
Goswami, Mr. Bachchan, Mr. Goswami,
Plus,
you come to para 30 onwards. 30, the conclusion is 279. And what is the discussion with regard to 337 and 304A? Materials considered. Only the injury to the lady was considered. And that was just a minor injury.
yes, because she somehow, my lord, she escaped,
Saved.
my lord.
But that is only a minor.
She somehow
So 304 ingredients against the accused can only be qua the deceased.
What is that?
Come to para 33.
I-
Sudden conclusion. How old is this boy now?
Not a boy, my lord, he's a man. my
Oh,
lord.
man.
He's retired also.
He was in service.
He was in service.
Retired now. Senior citizen.
Senior citizen. They got the claim from the motor accident tribunal. Some other decisions are also there, my lord. 304A, in a rash and negligent driving, my lord, the authority prosecution has to prove through the MBI report and all. Otherwise, who will measure what was the rush, what was the speed, my lord?
279, I can understand. There are material. But 304, there is no discussion. Mr. Goswami,
It would be the opposite. My lord, another issue of Andhra Pradesh, my lord, Madras, my lord, very clearly and emphatically said. Here, my lord, the central legal point established in the judgment is that to prove the offense under 304A IPC, the prosecution must demonstrate rash and negligent driving and mere speed cannot be equated to culpableness and negligence. But you will come to that paragraph. It's a long discussion, my lord. 18, paragraph 18.
Okay. Anything more, Mr.
There are 30, my lord, it says, my lord, we have in driving motorcycle in a very high speed without any illuminated headlight at the time of when darkness was prevalent at the place, my lord.
That again
would
is
mean, my
without
lord, that would mean, my lord, he is a negligent manner, my lord.
I got it, but
Yes, because
this
it-
condition of the
it-
vehicle is not
Yes.
without a report of the MVI.
Yes, it has been, yes, that part.
I'm not on that. If we can come to para 31, basing on that 279, nothing like it. He has been held guilty and convicted.
Yes, my lord.
But 337 and 304, what is the discussion? Nothing.
304A, my lord.
Nothing. Okay. Heard Mr. K. Bachaji, Learning Counsel for the petitioner.
A, my lord, intention is not necessary, my lord.
Okay.
Only by the negligence that can be found out that he has driven us without any light in the darkness, my
My
lord.
lord, it is in the month of May, 6:30. How can there be a night, my lord, evening? A month of May. Summer time, my lord. 7:30 is the dark, my lord.
I'm also heard Mr. MP Goswami, Learning Counsel for the Learner Additional Public Prosecutor appearing for the state. Hearing concluded, registrate to list this matter again. 29/10/2025 for delivery of orders.
Yeah, please, Your Honor.
Hmm.
Timing the case may be, is on the VC is not in our civil.
Continue. Serially material. One to give. Yes, Mr.
Still, I remember the earlier session. They have discussed the details about the evidence and the other things also. So far, my submission was regarding the incident. The victim himself saying that his incident took place on 1/1.
How old are you now?
My lord.
How old are you now?
My lord, at the time of
13 years. The matter is pending here.
Yes, my lord. At that time, my lord, when case was filed,
41
I was
years.
41. But my lord, my liability was, my lord, totally exonerated by the DW2, my lord. He is the wife of the, my lord. Is number 1. Specifically stated, I was not in the same, my lord. And regarding the medical evidence and the PW 1, 2, all are discriminatory, my lord. I said that there is some fishy might be there.
Yes. Who is there? Okay. Okay. What is the perversity in the decisions of the trial court and the appellate court?
But they have all hold that, my lord, I was involved in when, moreover, my lord.
PW1,
One.
one statement that you was there with a fana.
That is to be proved, my lord. That is nobody can say about specifically that who has inflicted which injury by which weapon, my lord. That to be determined. That to be specific.
That is difficult because which inquiry from which weapon, which thing, it's not possible.
And moreover, the doctor, my lord, in clause, it is specifically said none of the injuries is grievous.
And your other plea was of alibi. But I don't find your that cross. During the cross you have.
That is, I admit, my lord. But thing is there, my lord, the doctor himself stated that none of the injury is grievous in the cross. Specifically.
That is why 324 only. Penalty, the conviction
But
is under 324.
At least, my lord, whenever my
No, not 326.
This injury cannot be, my lord. It is, that is why it is getting converted to 324. But thing is that, my lord, my presence is whenever it is totally exonerated by the, my lord, DW2.
Show me how DW2's evidence.
Yes, my lord, DW2, my lord. The wife of the, my lord, Masamat, the Paritan Nessa, specifically stated
You have the cross, the evidence with you.
yes, my lord, one copy.
Can you just take me through that? DW1 is Mohar Ali.
He is accusable.
Tehirul Sun. There's which part?
Yes, when I got in that day. My name is Mohar Ali.
Mohar Ali.
Yes, my name was not there, my lord. When you see, my lord, kindly see the last 3
Line.
lines. Panchayat dia hoy edol disu.
What they are right, they only know. So soy Hadjon Manu As.
The meeting, that is, my lord. But I was somewhere it is fine, my wife found that there is this judgment problem, my lord, where it is specifically stated that my presence was not there, my lord.
DW2.
The wife of the accused number 1. And she was also later on exonerated because her name was not came into light. Although initially her name was there, but in the evidence, my lord, her name nowhere mentioned, whispered, so that is why she was exonerated.
It only says that Mohar Ali is not related to her. But exoneration of Mohar Ali or the presence of Mohar Ali, not there. You were there in the meeting also in the Panchayat.
The meeting was right there, my lord. So there is a village meeting, so obviously I should be there. But my lord, what is my modus operandi, my lord? I have nothing to do, my lord. Suppose, my lord, something is with the PW, this accused number 1, he's saying that he is sort of, he's taking goods on credit.
Credit not paying back.
Not paid. But what modus operandi with me?
Now, paternity.
But sometimes when it's jealousy and other things are always in this type of people, my lord, I'm frankly speaking, my lord. So this is.
But that is different. That we can only go by the evidence that is on record, Mr. Monto.
But my involvement also, my lord, from this specifically.
But PW1 is very categorical, and I've gone through the cross. Nothing is.
Yes, my lord. He has stated. But regarding the incident, my lord, this is saying they won one. Specifically, the person who suffered, he should not miss the date, my lord, at least.
Village rustic people, those
No, my
small
lord, 5
things.
days difference, my lord. Doctor has examined on 5th, and doctor specifically stated that the injury is 2-3 hours later, earlier, my lord. So in that instant, whether that will be incident took place on 1 or my lord 5-1, that he lordship have to come to the conclusion, my lord. And the FIR so far the police report is there, that is also my lord contradictory. Somebody said, my lord, 14 days later that was my lord lost, and practically that was 35 days later, and there is no explanation.
And the description, I don't find in the trial court, this contradiction was taken up. But in the
That is
appeal,
not discussed, my lord. This-
not discussed, not taken up, not taken up.
Yes.
It was there on the records, but it was not taken up. It was not considered.
Yes, sir.
Sorry for the word. But the trial court, the appellate court considered that.
Well, it is considered.
5 years delay
But-
in
Yes, it is there. But the delay, by the 35-day delay, my lord. This is not that 14 days or the 10 days. This victim specifically saying that 10 days delay. And the others said that 14 days. But FIR reveals that if more than 35 days, if the incident took place from 1-1, that will be 35 days. And if it is from the 5-1, that will be 30 days. So this is a fatal, my lord. And on what basis he was requisition? And that without requisition and without any document, doctor cannot well examine it. Then where is the requisition gone? That to be in record always.
I'll take you one step forward. If there is a requisition, there has to be a GD entry at least.
That must be there. They have to produce. Nothing was exhibited. So my lord, in that respect, I submitted that there might be one initial affair, initial ledger that has been suppressed, subsequently that has been prepared, my lord. I humble submission, but I may be acquitted from this on that ground, my lord.
It would have been a factor. But the evidences that have come on record have gone the other way around.
But evidence, my lord, this is coming later. But the thing is that evidence have to substantiate all the documents, relied upon them, all the entry cases, my lord. Where is that? They are saying that will not reveal anything, my lord. That to be supported by some document. It is very suspicious. The person concerned who suffered till blow, he even not properly explained the incident took place on which date. I mean, his father also saying the same thing on 1-1. And another uncle says that, well, that is on 3-2 or like that. And the doctor says that that was on 5-1, he examined. So it is from all these things, well, we cannot be safe to come to the conclusion that I was involved in that particular death, my lord. This is my humble submission before Lord. Otherwise, I leave it to Lordship or have to be Lordship.
Incident is of 2008.
Please, my lord.
22 years.
Yes, my lord.
And the present matter is pending for 12 years. Heard Mr. P. Monto, Lorna Council Court.
One point I beg to point out, my lord. In this case, my lord, initially, my lord was assaulted, and when was found, my lord, recovered by the my lord father, and information was lost on 6/1/2003 itself, my lord. Then this, my lord, apprehended one person, my lord, but he was released. Later, my lord, after releasing from the hospital, my lord, the FIR was lost on, my lord, 10/2.
There is a GD entry.
There is a record, my lord, that, my lord, initially one FIR was lost, my lord. That I can place, my lord, from the record.
This is the second FIR. I did not find it. Where
Yes,
is
this
that?
is the FIR, my lord, after releasing, my lord, from the hospital, my lord, he closed the FIR in the implicating all the accused persons, my lord.
Then what happened to the first FIR? Because you can't have a second FIR on the same point. Statement only. So, but the investigation seems to be
Yes,
done in
second
the second. First one was not registered.
That FIR, my lord, will kill my lord. The FIR dated 10/2, my lord. Lordship may kindly peruse that FIR, my lord.
10/2/2003.
May I read, my lord?
Yeah, read it.
Yes. Init নিবেদন এই যে যোৱা 5/1/2003 তাৰিখে ৰাতি 8:30 মান বজাত 1 নং পদকীয়াই, that is my lord, ফকৰুদ্দিন, my lord, who is my lord. পদকীয়াই মোক আমাৰ ঘৰৰ পৰা ষড়যন্ত্ৰ কৰি নিজ ঘৰলৈ মাতি নি উল্লেখিত পদকীয়াগণৰ সৈতে মাইলত, that is মাইলত the accused number 2, 3 and 4 he is indicating মাইলত, পদকীয়াগণৰ সৈতে মোক মাৰপিট
Mohor is also there.
yes more is also there man প্ৰাণে মাৰিবলৈ দেগাৰ আৰু মোৰ
This is the second FIR.
this is the second affair man.
Ah.
No my lord, that is
First affair.
there is an explanation man, that is why I am reading this affair my lord. মানে মোক 13 ঠাইত ঘপিয়াই গুৰুতৰভাৱে জখম কৰে, মোৰ জীৱনটো কোনোমতে ৰক্ষা কৰি আমাৰ ঘৰত লৈ গৈ অজ্ঞান হৈ পৰো, লগে লগে মোক চিকিৎসালয়ত ভৰ্তি কৰাই মোৰ দেউতাই মোক ঘৰৰ পৰা মাতি নিয়া 1 নং পদকীয়াৰ নাম উল্লেখ কৰি 1 নং পদকীয়াৰ লগত অন্যান্য পদকীয়া আছে বুলি যোৱা 6/1 তাৰিখে কুন্তলী আৰক্ষী চকীত এখন এজাহাৰ দিয়ে। মোৰ জ্ঞান ফিৰি অহাৰ পিছত মই প্ৰত্যক্ষ চিনি পোৱা উপৰোক্ত 1, 2, 3 আৰু 4 নং পদকীয়াক চিনাক্ত কৰি দিয়াৰ পিছত কুন্তলী আৰক্ষীয়ে 24/1/2003 তাৰিখত 4 নং পদকীয়াক আটক কৰি ৰহস্যজনকভাৱে এৰি দিয়ে my lord। দেখো যে মোৰ লগত সংগঠিত এই ঘটনাত কোনো প্ৰভাৱশালী ব্যক্তিৰ ওচৰত তথা চক্ৰান্তত সংগঠিত
So the first FIR was by his father
father my lord
on 6/1.
on 6/1 my lord। Thereafter my lord, one person was arrested my lord, he was my lord not arrested my lord, he was taken for
questioning,
interrogation,
but
my
he
lord,
was let off.
released my lord। Then after releasing from my lord hospital my lord, affair indicating all the accused person my lord। So there is an explanation my lord।
It is on 6, my lord.
Exhibit
That
2
too on
my lord,
6.
exhibit 2 is the my lord injury
It is
report
not
my lord.
exhibited.
This is item number
3 my lord।
okay. After 22 years, what will you get by putting him in back? That too for 324.
Charges leveled against him, that has been proved.
326 not proved.
It is not proved my lord, because doctor
324.
says my lord
It
he
was
was released
simple.
resumed to his work my lord, after 14 days my lord।
No deal. But
I-
I'm not.
But I want to rely on judgment, my lord. Where it
I'm
is
not.
missing.
I'm not touching the conviction. I'm giving you probation.
But I can rely one thing, my lord.
If I do that, if I go into merit, Mr. Monta, if I go into merit, it may not be.
Yes, my lord. But
After
lordship,
22 years, we are not interested.
lordship, my lord, only for the perusal of this, that will be help, I think, my lord, because the TT Anthony case, it is very clear that the subsequent affair trying to, my lord, is a very. But
After TT Anthony the Babu Bhai is the recent decision।
but whatever,
There is a recently I found.
another case, my lord, TT Anthony has relied, my lord. Because in the all the Supreme Court cases also, recent cases also there, when
The
subsequent
lordship
case
will
of
kindly
affair
say, my lord, this is a
is a
criminal
federal
division petition my lord।
Hmm?
A criminal division
Only criminal.
Yes, yes, on that
goes
issue,
to
my
the
lord.
merits of the case।
I am talking
evidence
merit,
of
my
the-
lord. I am only technical issue, my lord. The where
No,
the first affair is
reappreciate the
gone.
evidence at this stage my lord।
I can't reappreciate the evidence here.
My lord, this is where is the first affair gone? My question is this, my lord, only that will extent.
Okay. Did you cross the IO with that?
My lord, that is not there.
One.
Yes.
Have you crossed the
That is true, my lord, but
the second informant? Any suggestion? Nothing.
true, my lord, but the law point I can raise any point, my lord. It is nowhere bar that I can not raise in the subsequent.
No,
case.
if there is an explanation.
But this is their explanation, their record is saying, my lord.
No, I am submitting from the record my lord।
That is why I am telling, my lord. This is not exhibited even. I am, my lord, giving for your lordship.
No, this will be helpful for me. But Mr. Monto, the first FIR did not see the light of the day. It was only, it may be an information, but it was never, I think, even registered.
My lord, one thing, my lord, I kindly appreciate one thing, my lord. On the 5th one, he was, my lord, medically examined. That means, my lord, certain police requisition must be there. Where is that gone, my lord? Not material, not exhibit, nothing is there. And the victim himself saying that I injured reflected on 1/1. So that is the prior to the medical examination, must 4 days. This is my submission, my lord. Incident may be
The
there.
distinguishing factor is
Yes.
the first FIR here was registered. Thereafter, a second
Second.
FIR after 10 days was registered. Same incident.
So, my lord, here also, my lord, they
There
brought
is no
in
registration.
not registered, but this is the record is there, my lord.
That will,
Trying to, my lord, pixelize one thing, say, what found in my lord, in respect of the person. But the pixelize was, my lord, not in proper, that is why they come with the second one, my lord. My humble submission on that action, my lord, only.
Mr. Monto,
My lord,
we are not going into controversy. I'm thankful that you have given me
My-
this judgment.
my lord.
Going into controversies, we are upholding the conviction, which
Lord.
we are giving you.
My lord, as you lord, see, my lord, even then, my duty, my lord, I have to.
No, no, you have, I'm thankful for that.
Awesome.
Any problem?
Dispose, my lord.
Dispose. Yes, Mr. Vishwas.
Yes, my lord. This is the case of 2007. That is cycle was stolen from a college gate, my lord.
And then you had bought the cycle from somebody.
I have purchased it at bona fide purchaser. without any knowledge
PW5
that it
is the
was-
evidence,
On
but
the
PW5's
main
evidence.
culprit, my lord, he has admitted the guilt and served the sentence.
The co-accused.
So that is 379 against him.
But you were also brought within the purview of 379.
How?
You should have been 411.
Yes. Only 411 is there against me.
I have already submitted my lord. But from his position, my lord, stolen.
Position, but there are two things. The theft is not by him. So 379 cannot come against him.
While, my lord, while purchasing the bicycle, my lord, knows, my lord, whether it was his knowledge or not, my lord.
How? Show me. Show me that material.
That is what Supreme Court 25.
That material, because your witness says that he did not know. So 411 will also not come because the 411 there is a line. Knowing or reason to believe.
Yes, Supreme Court said 25, my lord.
First, set aside. What? Set aside.
All right. Should I give you Supreme Court?
Parivane hazi subhe? That's a side. Huh?
Well, the judgment is equal 25.
Please. Allowed.
Diploma.
Mr. Vishwas, apply for the copy. I'm not sure. Because they are under great pressure. They have requested me no disposals.
I do not. Since 2000, no
He is in
contact.
the outside, my lord. There is no worry.
No problem. Because my stenos had asked me, today, sir, no disposal.
Whenever you will pass the order.
No, today itself I'll do it. Don't
All
worry.
right.
Yes, Mr. Soikia, have you gone through?
My lord, it is very, very difficult, my lord. I could not go through, my lord, word by word, my lord. Every word is important, my lord, in this case.
Mr. P.J. Soikia, counsel for the petitioner.
Also,
Appellant.
at least, my lord, regarding the victim statement and one of
My
the
paper monk may be
and
directed to you, my lord.
PW1, my lord.
You go through from this.
This is
Uh,
translated.
Praise that he
Well-
be granted for the weeks, 2 weeks time to peruse the case records. Prayer accepted. Register to list this matter by Sekhe Pari.
3 weeks time may be granted, my lord. I have tried my best, my lord, but
22/10/2025.
already,
No further adjournment would be
My
granted
lord.
in the matter. I'm giving you the maximum.
my lord.
Mr. Goswami, any problem? Which one?
Other case, my lord.
This one?
Yes, this one.
Mr. Soikia's case?
Yes, my lord.
You read, we will be. Can't help it.
Well, actually, before going through the merit of
Looks like, yeah. Okay, Mr. Kamar is there.
Yes, my lord. To start with it, my lord, before going into the merit of the case, my lord, I'd like to concede one point. Last time there was an issue, my lord, whether when the public servant was acquitted, whether a private person can be convicted or not.
It
and
can
so
go on.
Can go on, my lord. That's by now. Earlier, when we joined, my lord, it was the different proposition.
I found not a judgment, but I was just searching for that. Discussion, point, a note, article.
Yeah.
Latest decisions were also.
I've given one Nalapa and I've got one.
That is gone. So that point we need not go
Judgment
into.
is there.
Latest, when is that judge decision of?
2025
Ah.
applied on this.
Enough.
Five relied on 2014. Very nicely discussed here. One is before charge and one is after charge.
No, there is a decision
Two
of the.
views are there, Delhi High Court and Bombay High Court. Has been settled by the Supreme Court.
Criminal petition.
Sikri and Radhakrishnan.
Criminal petition?
I said.
Okay. Mr. Kamar,
Yes, my lord.
can you just wait for 10-15 minutes? We will free up Madam first.
Oh, yeah, no issue, my lord.
Is
Madam, you sit down and argue.
Must always.
Mr. Bora, what do you have to say on that query that we raised?
Yes, my lord.
Ah.
To that point, my lord, the learned magistrate
Hmm.
only lordship has to see
Hmm.
whether he has applied his mind or not.
That's
That's the only issue.
Hmm.
And his application of mind, not to very lengthy. order-
page 18.
Yes, that the last part of the order, it appears that he has applied his mind considering the entire evidence. Page 10 of their petition, my lord. Last part of the order is very clear, my lord. He has considered everything and accordingly he has applied his mind. That is
No,
the-
means the satisfaction
Yes. His
cannot be only taken by only perusing the documents. There has to be
Yes, he's
something culled out from there.
Yes, considering the police report and the document sent by the under 173.
That is not a consideration, but that is, he is duty bound to remit himself to that only.
Yes, the statement recorded under 161 and the postmortem report of the victim and the specially dying declaration of the victim do not suggest involvement of the accused person with regard to the offense charged, my lord. That's enough, my lord. Do not suggest the involvement. That's enough, my lord.
Okay.
And to that effect, my lord, there are certain judgments also. Just I'm reading. It a deed. In the judgment, my lord, 1979 3 SCC 4, my lord. I'm just paragraph 10, subparagraph 4, my lord. But is exercising his jurisdiction under 227 of the Code of the Judge, which under the present code is a senior and experienced court, cannot act merely as a post office or a mouthpiece of the prosecution, but has to consider the broad probabilities of the case and total effect of the evidence and the document produced before the court, and basis of the infirmities appearing in the case, and so on. This, however, does not mean that the judge should take a roving inquiry into the pros and cons of the matter and weigh the evidence as he was conducting the trial. So that's enough, my lord. So he specifically says that he has gone through the entire material and dying declaration, there's no material at all. That's enough, my lord. And got my hand. And the second judgment also, my lord, same line, my lord, that is 2019 7 SCC 148, paragraph 15. Just, my lord.
Just takes up, reiterates Profuloguma Samal.
Yes. Yes. Same Profula Kumar, my lord. Thus, he has to apply the judicial mind, my lord. And in paragraph 18, the judicial mind is said, for limited purpose, whether the prima facie case is made out or not.
So you mean to say that if the judge is shown to have considered relevant materials,
Yes.
relevant particulars,
Yes.
and then came to a conclusion that, okay, fine,
Yes.
this thing does not disclose commission of an offense against the accused, then he is entitled to discharge that accused. No further discussion, reasoning of the evidences is required to be made.
Because he is not sitting on a trial.
The further argument of Mr. Lanak counsel was that he questions the very dying declaration, the manner in which the dying declaration was taken. He also questions the faulty investigation. Now, can this court in this petition go into that aspect of the matter? As an officer of the court,
Yes,
I must
ma'am.
say.
If there is a faulty investigation, that could have been raised in the trial court for the further investigation. Only the further investigation is permissible. That not been raised, my lord, at that relevant point of time. Neither they have that was the faulty investigation. And apart from the dying declaration, if we go by the other evidences also,
Tipali Medi.
everybody, my lord, every statement with the purely an accident, my lord. Purely an accident. So if you go by also,
And the dying declaration is also to the effect of a accident, even if
Yes.
we forget the manner in which it was taken.
corroborate the other evidences, my lord.
So if there is a faulty investigation, whether this court in its revisional jurisdiction comes to the notice, say in a given case, it comes to my notice that, okay, fine, you have done this, but this is not proper.
Yes, then lordship can go for the fresh
Further-
investigation or the further investigation.
This court would have the power.
Yes, yes.
That much
Only
only.
Constitution Court has the power for the fresh investigation or the further investigation. But as far as the magistrate is concerned, he cannot go
He
for
can
fresh,
he'll have to go for further.
only
Further.
further. That's the difference. And so my lord, whatever the material, suppose the learned magistrate is not very clear about his, even then, the material placed before your lordship, the lordship also can exercise the power under 482, because that inherent power is always there. Go by that power, my lord, whether the prima facie case is made out
of.
or not. The lordship also can see, not necessary that the lordship is bound to follow that the order passed by the magistrate.
Minister.
So because the inherent power is always there. So whatever the allegations, the statement recorded by all the witnesses,
Whether that would prima facie require this court to hold that prima facie offense against the accused is made out.
yes. If there is no prima facie case, my lord,
Then I cannot.
then no, my lord. Apparently, my lord, all the material, my lord.
And I can't go beyond, because this is a discharge application, I can't go beyond the charge sheet also. I'll have to confine myself
Yes,
between the
whatever the
materials in the
material
charge sheet.
collected by the prosecution during and if today it goes back to the magistrate, the same material
Same material will have to be
available.
Yes, Mr. Okay, thank you. Yes, Mr.
You allow me to sit
Yes, madam, you sit and argue. We will not allow you to stand and argue.
on this case. And the yes. Then it is only of 15 months.
We take it that it is within 7 months, 7 years.
Now I concern explanation just left in both the medical process, the investigation about date. Thereby, statutory provisions of section standard for VIP audited. And what the learned code below did. Only 498 that and it. Right? When end up February she died. It and was on 25th of January. Evidence is a parameters to establish that learned code below. He not applied the judicial. In the case after forget about dowry date. Because it is a date of a person, date of a young lady. Now, what the other court below did, yes, there is no privacy case. That's why discharge. Privacy case is apparent, my lord. Why it is apparent? The date, not only death, causes burn date. And burn is also what is in there, because that you can tell this thing.
Your
Burn.
Honor, this dying declaration,
Dying declaration to
dying
say-
declaration
say-
language, very important here. And the writer of this dying declaration, Neha Agarwal.
Oh, Sneha Agarwal. Page.
You're getting
Neha
it
Agarwal.
in-
Okay. Okay, what do you have to say on this?
about Sneha Agarwal, Your Honor. That is in that is in page number 21 of objection. That I am doing an intensive presently at GMCH. Intensive, she is not a registered doctor, Your Honor. And nowhere it is reflected in here that she is the writer of this dying declaration. Also, there is no time stated anywhere in this.
This term recorded. Yes, Agarwal. Time or just to take it forward, when the charge sheet is filed, a copy is given to along with documents to the informant also. You are heard at that point of time. You have a right for hearing. Now, did you raise these issues before the? Because this is a case which you could have raised claiming further investigation before the court below. A factual, this is not a question of law. This is a question of facts, the manner in which it was done. But you have not done that. Have you done that or not done that?
Itself is a vague. There is no clarification in the.
No, I want from you.
At that point of time, I was.
Whoever it is there, the respondent who is instructing you was there.
Definitely this question. I think so.
If this question was raised, the trial court would have stopped in its course. Okay, fine. We have got it. Now we are hearing it. Forget the impugned order. Now, what is the error in this page 21?
Page 21.
The objection. The dying declaration.
Declarations.
No date, no thing. We take it out of the equation. This dying declaration, we are taking it out of the equation. Right? Because it is not a document which implicates the respondent. It is not implicating the respondent here. Right? So we take it out of the equation. We hold that this is not existing.
Then my second point of time factor also give one time factor also is such this dying declaration.
because of the inherent deficiencies pointed out, let us assume that this is not there. Because this is not implicating.
Two types, Your Honor.
Mr. Stout, this is not implicating, this dying declaration is not implicating the respondent, husband here. She exonerates him from that, accuses him, or he is freed from that by this tenor of this dying declaration. The respondent is not being implicated. So let us remove it from the.
Tell me to say so.
Where?
Statement.
Where? Then you will have to come to the other statements.
Also,
No. We'll have to take a prima facie view of that. Na? You come to Bhavesh Bhuya is the complainant.
Yes.
There was no demand for dowry. Okay, we'll come to Dipali Deka. The evidence of Dipali Deka.
credibility also comes, Your Honor.
Mister, we are only trying to, we cannot, we are not holding a trial. We can't hold a mini trial here. We can only look into for a satisfaction whether an offense is made out. If we find that it is an accident, the end of the matter. Or show me that in any case wherein materials have come on record that it is an accident, but still a trial has to be held. Just show me a decision. I will ask Mr. Bora to go to there and cross, not argue here. I don't know. I'm not very conversant with, I'm just trying to learn as a student of law, criminal law. So you guide me out.
On speaking this with FIR, if we will corroborated everything from 161.
Mr.
Your Honor, indulgence, why we want indulgence of this court?
See, while I'm giving you indulgence, I cannot put the right of a citizen to the sword. The liberty of a citizen to sword. I'll have to balance, and that is exactly what a court is required to do in such circumstances. I take out the dying declaration because it is it is a very safe material to come to the conclusion of no offense. We take it off. But then there is Dipali Deka's evidence. Dipali Deka, who is there at first floor. Then there is Dhoranidhar Deka. Pankaj Burman, then Bimala Bhuya.
Time factors also.
And all these evidences, all these witnesses have deposed that it was a mere accident.
Us is the own sister.
Meenakshi Das. Where do I get that page?
Page 19 of my. Pankaj Normal, other Milo.
So,
Other.
Pankaj Burman.
Antonu.
The brother of victim. Where is that? Where is that? Well,
Last dying declaration.
Dying declaration, yes.
hmm. We have taken the dying declaration out of the equation. We are not considering that. (161) is nothing, but for arriving at a conclusion, prima facie case, we can always consider that because that's the only thing which I can consider. And I can consider maybe the PM report, which will be there. PM report also does not. Why? You are standing there to say why a permission is required.
Your Honor, about the time factor in 161 statement in the objection of Pankaj Dhanidhar Das. Who get the information, from whom they get the information, and the time factor. Your Honor, when the things are not reliable, when the credibility is in question, it's important to.
So your sister's credibility is also in question.
Yes, Your Honor. Yeah, but one by one, allow me to submit, and I will. First, both are independent. Pankaj is the brother-in-law of the accused, and Dhanidhar Das is.
Brother-in-law of the accused means what?
Brother of yours.
Pankaj Burman.
Yes.
Pankaj Burman is the brother-in-law of the Santanu. And
Where do I get Pankaj Burman?
Pankaj Burman, page number 12.
My wife is Santanu's elder sister. Oh no, the other way around.
Relative, man.
Relative. It is related, relative.
And
so he is married to the sister of Santanu. So he is in Santanu's side. We ignored this also. Okay, but he is in Santanu's person. He is a relative of the accused.
he is the person who is the first person who appeared there.
We ignore his evidence also.
Your Honor, his evidence is very much important.
Okay, come on, talk.
In the second paragraph, last part of the second paragraph, I immediately took both of them to a medical near Tanagar police station in my car. But as burn case were not admitted there, that is why I took them to GMCH after taking first aid. Now, when there is a burn case, it is to be registered by the hospital, but there is no explanation of that. And the medical...
Mr. Sitawat, one thing. This is a situation wherein he sees somebody burning. He takes them immediately. That's a normal human course of action. Finds a, what do you call that, a pharmacy or something. Gets her a first aid there and then he does not stop. Immediately takes her to GMCH. Right? That's a normal human course of action expected. Then
now at GMCH, I'm not talking about the duty of the Pankaj Burman. I'm talking about the when the case is burn case, when a person has been burned in a hospital, it is the duty of the hospital. It is in the record, and that record has not sent to the CGM. That record, we want that if that record will come before the court, then the court will decide at that time. All the materials things are there in the record.
What will you get from there?
In the postmortem report itself.
The extent of burn injury is there in the postmortem report, right? The cause of the death is there in the postmortem report, right? Anything more from that you want in the records?
Only by
It's just for a roving inquiry. It can be only for a roving inquiry because it will not bring on record any material against the respondent herein. Anything more?
the discrepancies are there. Not
We have noticed it. We'll notice. We have noticed it. We will take care of it.
Dipali Deka and the Pankaj Burman's. Before that, the time factor which I says at 8 p.m. Dhanidhar Das came from the office. It is in the record. It is in their objection. That Dhanidhar Das has came at 8 p.m. and at 7:30, Pankaj Burman get call from Dhanidhar Das about the incident.
Okay.
Now about the story on Dipali Deka and Pankaj Burman. Stories are not cooperating with each.
Any decision you want to rely upon? Just tell me the citation.
1 GLT
2002 1 GLT 355. Next one is 2002 6 SSC. How is Gagannath Patnaik helpful? Okay.
Of 2 persons, Your
Huh? Of Vimula Bhuya is
mother of the deceased.
Okay, then next one.
And that
One more statement you said about someone.
Hanidhar,
Please, I'm here.
Dhanidhar Das.
Thanidhar Das. Thanidhar Das.
Dhanidhar Das.
So these two statements you say were not given the appropriate consideration. Okay. Anything more?
কেতিয়া তোমাৰ
report when the postmortem and when the cremation very important when the report record will then put there is a lacuna in utilizing the judicial. So, Your Honor, when discharging the order, clearly that percentage and the nature of burn, kind of treatment given, which
That is there in the PM report. And during your statements, the mother's statement of the victim or the brother or the informants, has any statement been brought on record that while she was in GMCH, she was not being given proper treatment?
they have not given proper care of that.
That's what I'm saying.
that
The doctors have not given proper care. Is there anything? Is there anything on record to that effect? When the patient is in the hospital, it's for the doctors there to provide the care. The care cannot be provided by a non-doctor, a non-medical personnel. Is there any allegation or in the any statement made by you, 161, that the doctors there were not providing because of the influence of the respondent? Okay, thank you. We'll consider all those things. Don't worry.
I'm just adding few things, Judge. My lord, I failed to understand what they are saying, my lord. Just it's not a trial, my lord. Whatever they are saying, if there is a faulty,
Mr. Bora,
if it is a faulty
Mr. Bora, they have
investigation-
their right to take out their grievance. We have taken.
The grievance, but it has to be justified grievance, my lord.
That's for you to say.
They cannot bring anything, my lord, which is not out of the record. And the grievances they have put forward before your lordship, it goes to show if there's a faulty investigation also, then also it's a benefit goes to me, my lord.
It
I
should go to you.
cannot be a victim of the faulty investigation. The husband cannot be a victim of faulty investigation. How can a husband be a victim of a faulty investigation if that be so also? Now, if there is not an one dying declaration, my lord, in this case, apart from the doctor, if lordship is saying that let us not take the doctor's evidence, if we go by the other independent,
all have said
in concert that it is an accident and she, the victim, made the dying declaration.
They have not said that it's an accident. They say that the victim had said
Yes.
that this is a accident.
So this is a dying declaration, my lord. Because
Even her own sister is saying that.
Yes.
From whom the cylinder was taken.
Yes. And it's all dying declaration, my lord. It's all dying declaration, my lord. It's not just a statement because it connects with the death of the victim, my lord. And the 7 years presumption, it doesn't come here because it's not a dowry death, my lord.
There is no demand for dowry.
No demand for dowry. in case of a demand for dowry, if somebody dies within the 7 years of marriage, then only the presumption comes. There is not a whisper about the demand of dowry, so there is no question of any presumption here. Now, second point is that, my lord, in case of an discharge, my lord, if there is a two views is equally possible, then lordship can remand back
The matter.
for the trial.
Right.
If
It
two
is the
views
other way around here.
If it is other way around, there is no two views is equally possible.
Possible. And if in a trial, if two views is possible, it goes to in favor of the accused.
Yes.
But in question of discharge, while
Yes,
considering discharge,
Yes, absolutely.
then it has to go back.
Yes.
Because that view which is favoring the prosecution has to be taken.
Yes, absolutely. But here, there is absolutely no two views. Had it been a two views, yes, I could have considered that, yes, there's two views and let us go for the trial. But here, absolutely all the evidences, all the material collected, the landlord's wife, the sister, the own brother, everybody. And it's not a case of a grave suspicion, my lord. Had it been a case of a grave suspicion, then also court can frame a charge. But only if it's a case of a suspicion, then court also cannot frame the charge. There's a judgment also to that. So, everybody, my lord, there's all the dying declaration. Relative of the victim.
Mr. Bora, anything more is required?
Nothing is required.
We'll consider the objections and then we'll come to a conclusion.
My lord.
But Miss MS K. Devi, K. Deca, learned. Item number kiman asil to? 30. K. Deca, learned counsel, along with Mr. S.P. Chittawat, CHITTAVAT, learned counsel appearing for the petition. Also heard Mr. A.M. Bora, learned senior counsel, assisted by Mr. learned counsel for the respondent. Also heard Mr. M.P. Goswami, learned additional public prosecutor appearing for the state. Hearing concluded, raised to list this matter again on 28 तारीख पाई नहीं 29/10/2025 for delivery of orders. We'll talk. Madam, thank you for being here.
I'm blessed. And only.
Mr. Chittawat, we will take, don't worry. The manner the court conducts, maybe people sometimes presume that I'm against, but I only try to extract. This is for extracting only. All right. Where is Mr. Kamar?
Senior counsel is on his way. He'll be here any minute.
Okay. You take the field. You start off.
Lordship, in this case, prima facie, the order of conviction is bad in law because, first of all, as on going through the depositions, they found that the consent under Section 6 of the Delhi Special Police Establishment, that is not there. So, on what ground has the on what basis has CBI conducted the investigation? That comes into question. Secondly, the charges framed are quite defective. We have annexed it in the memorandum of appeal. Senior counsel is here.
Oh, no, you, Mr. Senior Counsel will be there. We'll hear him finally. You continue.
Lordship, in the charge head.
My lord, with all respect, I am not disturbing him. Going into the merit of the case, my lord, I would like to raise two preliminaries. If that cuts the ice, my lord, then there is no question of entering into the merit. So I'll ask him to submit.
He has started off on that only.
Yes. Charge is not now the issue, my lord. Charge when will come on the merit.
Section 6.
Yes. And for that evidence to the
Yes, what do you have to say on section 6?
Lordship, in the depositions of one of the IO, it has been clearly stated that the consent is not in the case diary, and in no way, the consent to hand over the investigation to the CBI is not there in the case diary, and neither has it been exhibited in any way. So on what basis the CBI conducted this this investigation, that comes into question. Without
Yes,
that,
ma'am.
the CBI cannot conduct. In fact, we look at the way in which Section 6 has been written. Nothing contained in Section 5 of the Delhi Special Police Establishment Act 1946 shall be deemed to enable any member of the Delhi Special Police Establishment to exercise powers and jurisdiction in any area in a state, not being a union territory or railway area, without the consent of the government of that state. So that is the means at the very genesis itself, the
Was this issue argued before the trial court? What is the conclusion of the trial court?
not there.
It has come on evidence, my lord. We have argued it, but the judge conveniently left it, my lord.
Mr. Amar, a specific case, if there is no consent given, but if there is a general consent given with regard
No,
to
that's
that,
that's a general concern will be.
no. With regard to the cases of Oscar Bank, then-
Nothing as such, they have brought it on record that they.
but I think there was a, madam, there was a general consent given by the state with regard to all the cases pertaining to, you have that on record somewhere?
Let us show, my lord, I'll take my seat.
One up. Stood on 9th July 1991. Our,
Huh?
it is annexed with our reply. Only
You
one.
have filed a reply here.
Reply is one thing, my lord. and to
It was
bring some
annexed there
evidence
in
on record
pursuance
so
of
that
the
I can-
notification.
I can take a chance while cross-examination is a different thing, my lord. Without bringing
exercise
it on
of the-
record now, making it come to backdoor should not be permissible.
The public document, without this notification, CBI cannot conduct the.
But I have
It is there.
examined him in the trial.
Yes, sir.
Not on record.
How was this question put in the trial?
My lord, your lordship will kindly see from PW 20, my lord. Just before that, my lord, I know your lordship knows it, my lord. A CBI will step only by two methods, my lord.
Kamar,
My lord.
that statement knows that this court knows nothing.
No,
So
my lord.
listen,
I will never accept that, my lord. My lord. So,
yes.
I'm submitting, my lord, it will come by two ways, my lord.
Hmm.
One, that is, my lord, that court, High Court will direct it to take up the investigation, or state will give the consent under Section 6, then only the CBI can.
Can take over. Because here in Askat Bank cases, I think I found
They should
somewhere,
have exhibited that. The IO was cross-examined at length on that point. I'll show it.
but he did not.
No, nothing. He kept mum.
And that is the first preliminary point.
Yes.
Second is?
My second is that once the 120B was there, the genesis of the case is that both the persons conspired to do something.
But the other one was
Acquitted.
acquitted.
Yeah, whether the single person can be roped in into that
with
or
120B.
separate offense.
And you have also been acquitted of 120B, but
Yes.
120B was brought in for the other act.
Other accused, and that is the charge sheet. I'll show what the IO says, because
Okay.
normally we don't
We
start.
have
the
a
case with
meeting
the
at
IO.
1 in the bar today. I've got it. Can you make a small note of the arguments which Mr. Kamar would take point wise, along with the PWs relied upon on the next day. Madam,
The notification one.
we got it. We got it. We got it. We got it.
Public document is not to be.
But Mr. Z. Kamar, Learned Counsel, Learned Senior Counsel, assisted by Mr. Dev Chaudhary, Learned Counsel, appearing for the appellant. Also, the Learned Counsel for the appellant was heard at length. However, the hearing remains inconclusive. Raised to list this matter again on 28, 29. Any problem?
Of
October. 29, madam, 29, 29/10/2025 for further hearing. Yes, Mr. Chaudhary, what are you waiting for?
It is not possible that my bail may be considered. What are the matter of hearing? Almost 4 years already gone by.
Mr. Ahmed was arguing this
Yes,
matter.
last time he was.
We will have it in the second half. Don't worry. We'll hear the matter today.
Second half. Only you also accommodate me, my lord. That's
Uh-huh.
by some other court I have some cases.
It is that POSCO matter.
POCSO matter, but only supposing if conviction is held, matters. I am on that subject to my own. Now, whether matter it is penetrative or aggravated matter. If it is penetrative, it will come to may extend to 7 years. In that case, my lord,
Or if it is aggravated, then it will be 20 years.
Not 20, my lord, because it's prior to the amendment.
Or prior to the amendment.
So
huh.
10 years would do.
10 years. So 10 years was given.
That, my lord. If it is penetrative, aggravated goes.
Excellent. 22 to some.
Yes. Even if lordship, suppose if your lordship finds that in that case also, it will come under section 4 or section 10, my lord. Punishment. Your lordship will find that is hard statement, PW, my lord, that is victim. PW 2, my lord, page 9 and 10. Tried, my lord, that is hard. First kindly see the section 3, my lord.
Just a moment. Just a moment. Mr. Chaudhary, one factor which I would like to.
My lord.
The 29 and 30 of the POSCO Act, the presumption will be after the foundational facts are laid down. The foundational facts here, prima facie, subject to what you say, have been established.
Attempt. I'm only on attempt that part, my lord.
No. But where is the stand of yours? Because in 313, it's basically denial.
Yes.
There is
You also know,
that I didn't know. That I should not know. That where the trouble is.
My only question, my lord, your lordship.
Whether it's 4 or whether it's 6.
That is,
We'll examine.
But that is the only question, my lord. I'm not saying that I'm so innocent, my lord.
No. 4 or 6, 7 years or 10 years.
Or 10. No, it will be 5 years or 10 also, my lord. So that way 4 years already gone, my lord, I think.
So 1 more year. I think he's eligible for, if I take 4, it's eligible for.
My friend will, my lord. He will
Okay,
not do so
taken
much
up.
unreasonable, my lord.
You come back when you are free. We'll take up the
Fine,
matter.
Only can you accommodate, my lord.
Sure. Now tell me why you are sorry.
Because I could not appear when matter was called.
Which one?
Item 16, my lord.
কি কৰিলো এইটো? Okay. 16.
I
So,
got the copy, man.
I'll do. Copies
I
I've got.
got.
Good. It was that matter wherein
2 years conviction. My lord.
what was the issue?
13 lakhs
15 lakhs. 13 lakhs recovered.
recovered.
What is that? We'll uphold the conviction.
Release in 2013.
406. Ingredient satisfied. 2 courts. Why should this court come in and interfere? You show me. What is the error?
381, convicted 381.
381 as a clerk. Misappropriation by a clerk. Yes. Materials are.
One question is this, my lord, while
You have not disputed the entrustment.
it doesn't, but I clearly mentioned in my my evidence, DW1, that has not been totally not considered.
Okay, but did you cross that point with the other PWs? You have not raised that point with the other PWs.
Cross examination is there, cross is there, and evidence of PW2.
Okay, we'll see. We'll see what we can do for you. 1710, na? 1710. We'll see what we can do for you. Non appears bole likhibo na lage, J Ahmed bole likhi diyo.
And was for hair father hair.
J Ahmed bole likhi diyo.
For
But
father
Mr.
hair.
J Ahmed. Huh?
For father hair.
No, for delivery of order. If you want 5 minutes, you can tell me what is there.
And my lord, what happened in this case?
Okay, Mr. Ahmed, enjoy your vacations, come back. We'll see. Boy, yeah, go there for father hearing. Go there. Father hearing. Go there. We'll hear.
High level.
When Mr. Ahmed says something, we can't say no. Na.
Because I am also lacking court number 3.
All right, now today is the day you should be in legs. Yes.
Lordship, I appear virtually.
Have a
I had made my lordships and my written submissions were on record. My synopsis was submitted to your lords. If your lordship wants, I can give a brief summary of what the issue.
No, it's already here. Yes, Mr.
What we will have a look at the notice which was issued during the audit. Starts at page 27. Also, we will see the, my lord, heading part, my lord, what was found, my lord. Short payment of tax in GSTR 9. 1 and 2, separation of turnover as per records and books of accounts. And this was finally settled, my lord. Now, subsequent to this, soon, my lord, Stokoe's notice was issued in 46, page 46. On 28/9/2023. Proceeding has been drawn under section 73. Also, you will see, my lord, their entire ground is that, my lord, in ground number B, it has been on filler of GSTR 9. That GSTR 9 or audit was the assessment was submitted.
But in page 27,
Yes,
that is the
page 48. Page 48. May I read it, my lord? It says you have filed annual return in GSTR 9 for the financial year 2017 and 18. If I read further, on examination of the information furnished in his return under various heads and also the information furnished in GSTR 1, 2A, 3B and EWB and other records available in the office, it is found that you have not correct tax liability while 9. Summary of under declared tax is as follows. Also, we'll see the heading first part. Under declaration of output tax. And my lord, next is page 49. Is excess input tax credit claimed on account of non-reconciliation of information. My lord, under declaration of ineligible ITC. So here, my lord, two headings, my lord. So far as the first part is concerned, my lord, we have admitted in our affidavit that, my lord, this was already considered at the time of that audit. Similar to page 27, first part. But second part, my lord, regarding that claim of ITC.
Hmm.
That part was not considered at the time of, and that we have stated in our affidavit.
Page?
Also, you will find it at page. No, 65. 16 Roman 2. The second para of 1-2 para says the first issue in the instance so cause notice is regarding short payment of GSTR so and so, and the second issue is regarding availment of input tax credit amounting to rupees so and so in contravention of the provision of section 17(5). Now it says that though the first issue was discussed during the audit assessment, so we have admitted that part. Second issue was not discussed or notice. Against this, my lord, the reply, what they have stated, lordship will find that para 25, page 84, current running page number 84, para 25.
$84.
84.
Hmm.
Third line from the bottom.
Hmm.
Additionally, regarding the second issue, concerning the LS wrongful availment of input tax credit amounting to rupees so and so, the petitioner contends that since a comprehensive audit for the relevant period was already been conducted, it is wholly unreasonable and unwarranted for the department to issue a so cause notice on this ground. So this is the basic ground, my lord. So far as the second part. But there is not a single denial that, my lord, no excess input tax credit has been availed by the petitioner or undeserving input tax credit has been availed by the petitioner. No denial to that effect. On the technical point, they were given the reply. So my humble submission will be, even if in the so cause notice, it has been mentioned as, my lord, non-filler of GSTR 9, my lord, going by the subsequent part.
You mean to say that it has to be read as a whole
Yes,
document?
because, my lord, this line, my lord, in page 48, you have filed annual return in so and so on examinations.
Anything more?
My lord, I would like to place two, my lord, judgments in this regard, whether at this stage, my lord, at the stage of so cause notice, the honorable court should interfere. There is nothing to show that, my lord, we have acted, my lord, beyond our jurisdiction. And in, my lord, a total abuse of the process of law. My lord, I would like to place, my lord, 2007-13 SCC 270, para 31. Says, my lord, normally the read code, internal page 283, para 30. Normally the read code would not interfere at the stage of issuance of so cause notice by the authorities. In such a case, the parties get ample opportunity to put forth their contention before the authorities concerned and to satisfy the authorities concerned about the absence of case for proceeding against the person against whom the so cause notice have been issued. Abstinence from interference at the stage of issue of so cause in order to relegate the parties to the proceeding before the authorities concerned is the normal rule. However, the said rule is not without exception, whereas so cause notice is issued either without jurisdiction or in an abuse of the process of law. Certainly in that case, the writ code would not hesitate to interfere even at the stage of issuance.
Got it.
So this is my point, my lord. There is no abuse of the process of law and it is within our jurisdiction. We have admitted in our affidavit that first part, it may be within the, my lord, audit part. The second part, my lord, there are some discrepancy. He can, my lord, very well take every ground he wants to take while submitting the reply. So I humbly pray before the honorable court that, my lord, this so cause should, my lord, at least this honorable court shall allow the authorities to proceed on the second ground, my lord. At least at this stage, at the stage. He can always file a appeal against the final.
We'll consider.
Lordship, may I just submit 2
One
points?
more judgment, my lord. Para
What my
5,
learned
just
friend has argued, Lordships, on the point of alternate remedy, Lordships. Allow me 2 minutes to counter that.
And one more, my lord, point, my lord, one more point.
Without any
Lordship will
judgments,
see, my
I
lord,
will
they
not
have
place any
referred
judgment.
to.
No, he is not arguing on alternative remedy. He says when a show cause notice is there, it is that proceeding that should be taken forward, not this. That's the only argument.
Lordships, I will just submit 2 minutes once your my learned friend.
Just a moment.
Lordships.
They referred to a, my lord, office notification.
Page 103 notification.
That notification. Yes, Lordship will see, my lord, annexure. Page 103. Regarding 103. Says regarding notice issued based on IIT Big Data software. Para 2, the petitioner has relied upon. The cases where return scrutiny proceedings have been completed and notices again issued using IIT Big Data software needs to be dropped to the extent of the para which are already covered in the my lord. That part I did not say further, my lord. Extent of para which are already covered in the previous. So, my lord, second part remains, my lord. He has relied upon this. This supports the petition, respondents, my lord. This is my humble submission, lord.
Yes, Mr. Anything more? Nothing?
Lordship, first, because the Lordship is at page 103, I will just 103. I have never relied on clause 2. I relied on
You
clause
relied
1.
on clause 1.
Lordships, because it is on
I will
audit
have
proceeding,
two
not
in
a
that
scrutiny proceeding. Lordships, so first, I would like to point out to this honorable court. Second, Lordships may kindly take the first order passed by this court on 6/11/23 when the petition was admitted, and it was a detailed order to the extent of jurisdiction being challenged to issue the show cause notice. The court was satisfied to the extent that yes, it is a jurisdictional error while issuing the show cause notice, and hence the petition stood admitted. Today, my learned friend comes and tells, no, this petition could not have been admitted at show cause. Lordship, it is abuse of law. Lordship, then this order of 6/11/23 passed by the coordinate bench detailing as to what is the jurisdictional error. Why this honorable court would interject in a show cause notice issued once an audit under 65, which is a detailed process as defined under 213 of the Act. How can an audit, after completion of an audit, that point, Lordship, on the issue, on the...
Mr. Kanodia, you have made a statement. Now show me the reasoning of the court in that order dated 6/11/2003.
No, not the reasoning, Lordship. I am just saying that the court, honorable court... No, Lordship,
I would like prima facie finding.
Prima facie
if it is the if you submit that is the final thing, show me a law. I'll confirm that and I'll do it.
Lordship, not the final thing.
Be within the parameters of law.
Lordship, I am within the parameter. I will not argue anything
You
outside,
say
Lordship.
that this court had made a pass the detailed order.
No, noting the facts. Only the facts I'm saying.
That is of neither here nor there. That's a issue for examination.
Lordship, which
prima
Lordship
facie satisfaction. Now we are examining the matter.
Lordships, now
we'll have to go into both the sides. Hear both the sides. We are hearing that.
Lordships,
we'll pass the orders.
Lordships has given sufficient opportunity. Lordship, then in that case, what are the judgments which have been relied by my learned friend? If I can submit my counter to that within 2 working days.
I'm sorry.
Lordship, because those judgments were not...
The judgments are to the effect that show cause notice being issued, the same should not be stalled by this court, and that are not in relation to your GST or tax matters. That is a general principle of law. Even without a judgment, that can be gone into. Okay.
Lordship, then in that case, Lordship,
the Learning Council for the parties at length. Hearing concluded. Registry to list this matter again. Date 24/10 for delivery of orders.
Grateful, Your Lordships. Much obliged. Grateful, Your Lordships.
Yes. Oh, wait a moment. Yes, Miss Paul.
Chip, as per my instruction, since April he is not attending the till now in the band. So kindly, if your lordship fix the matter after vacation, so that he.
Dismissing your petition. This is your petition. You're not arguing. Why should we keep it in pending?
Chip, actually, I have.
There is a stay order. We are
actually-
vacating the stay order.
Huh?
We are vacating the stay order.
Lordship, kindly till the after vacation.
Today argue it or we are vacating?
No, Lordship.
That's what the adjournment was given to you on 2 occasions. Please don't be so take this quote for granted, Miss Paul.
No, Lordship, just appreciate.
What should I appreciate?
Lordship, he's completely bedridden, Lordship. That's why I could not properly talk.
He is not to come here and argue. He is only to instruct you.
Today's one problem is that actually I brought the wrong.
You have a medical certificate that your client is not keeping well. He cannot even give you instructions.
Next question.
No, you were supposed to place that. You made the same submission last time. We are vacating the interim order. And then you will start coming. No interim order. Stay. Where is the stay? Which order?
21-3.
Okay. Heard Miss J. Paul. We are vacating this stay. Learned counsel appearing for the petitioner. You also want it to be in Gauhati only. This Divi case.
Only wanted the transportation conveyance.
He is not in a position because for the last 6 months.
Now we are passing the order. He will either go there or the case will get dismissed. 3 times you have taken.
Because expenses he cannot.
No need. We are dismissing the writ petition. That's all. You have nothing to submit.
Then also I may be allowed to withdraw.
Withdraw. Ms. J. Paul, learned counsel for the petition on instruction submits that she be permitted to withdraw the present writ petition. Whose prayer is not objected to by the learned counsel for the respondents. Accordingly, the present criminal petition, transfer petition, bracketed criminal, stands dismissed on withdrawal. Interim order passed earlier stands vacated. Get a stay and then 3 dates I have given you. Only thing they wanted was give them that transportation cost, whatever it is. Get the
Family get.
Now you go to Hazu. You fight out the case there. None appears for the petitioner on call. Mr. R.J. Burwa, learned. Additional public prosecutor is present. Also, none has also entered appearance on behalf of the respondent number 2. Seems both husband and wife may have reconciled back. Both are missing. For the ends of justice, raised to list this matter again after the ensuing vacations on a date to be fixed by.
Of argument.
Okay. He's a busy counsel, so he'll naturally be on the miss. What have you got to say? Mr. P. Sharma, come decide. Mr. P. Sharma. But Mr. P. Sharma, learned counsel for the. He's there in the court today, along with Miss A. Das. K. Das, learned counsel for the petitioner. So, the present review petition has been instituted, praying for review of the judgment and order dated 27/11/2014 passed by this court in WPC number 2584/2024. This court has perused the grounds urged by the review petitioner and find that there exists, then finds that a prima facie case for review of the said order has been made out accordingly. So, made out. Full stop, huh? Subpara. Issue notice to the respondent number 1 only. Full stop. Petitioner to take steps for service of notice upon respondent number 1 by way of registered post with AD. Petitioner is also permitted to take steps upon respondent number 1 by way of dusty mode routed through the registry of this court. So, on taking a service, in the event notice is served upon the respondent number 1 by way of registered post with AD, by way of dusty mode, petitioner to file an affidavit thereafter. Registry to list this matter. Steps within 2 working days from today. Registry to list this matter after 4 weeks on a date to be fixed by. Tell Mr. Sharma not to have any here. The notices have been issued.
Please, Lordship. Last occasion, Lordship, arguing on the basis of medical report, Lordship, is about 10 years by the appellant, but the medical was not supported, Lordship, and corroboration is not there, Lordship. And on that basis, Lordship, I'm judgment, Lordship. But sometimes, Lordship, the victim statement, and that because she is a minor and aged about below 10 years, Lordship. And if she committed rape, Lordship,